I have a quick announcement, Judge.
Court is once more live. This is the civil probate and guardianship docket for Tuesday, August the 4th, 2026. The time is now 2:16. Ms. Noriega.
In person, Council Andres Reyes, page 3, number 8.
This is in the estate of Carlos Peña, cause number 2026 PB 732L2. Good afternoon, Mr. Reyes. Court marks you present in person. Carlos Peña Jr., are you present? Please step forward. Mr. Peña, please step in front of one of the microphones. Speak very loudly into it and tell the court, are you Carlos Peña Jr.?
Yes, that's correct.
Welcome to court, Mr. Peña Jr. You're joining us live in person. The person to your right is your lawyer counsel. What is the announcement?
Judge, we are ready to proceed with the application to probate will.
Mr. Peña, would you raise your right hand? Do you solemnly swear or affirm the testimony you will give in this cause will be the truth so help you God?
Yes, sir.
You may lower your hand, Mr. Reyes. Go ahead.
May I proceed, Judge?
Yes,
Judge,
sir.
I would ask the court to take notice of the motion to set this probate matter for hearing. And I will note that my motion indicates, Judge, that all the prerequisites for coming here today have been met, including filing of the application for probate, the proof of death that has been filed, the original will has been filed amongst the records of the court. We filed a proposed order, Judge, and also we filed a blank oath of office.
Court takes notice.
May I proceed, Judge?
Yes, sir.
Will you state your name for the record?
Carlos Peña Jr.,
Mr. Peña, where do you live?
107 West Locust.
Sir, you are the applicant in this matter in the estate of Carlos Peña, deceased.
Yes,
And what was your relationship to Mr. Peña?
my father.
Mr. Peña, your father, prior to his death, he had been married, yes?
Yes.
And who had he been married to?
My mom, Maria Salinas Peña.
And she passed away before he did.
Yes.
And during his lifetime and your mom's lifetime, they had children. How many were there?
World War IV.
And those are the only children that your mom ever had?
Yes.
And those are the only children your dad ever had?
Yes.
And the particulars of their life together were laid down in the proof of death, is that true?
Yes.
And during his life, where did he reside, sir?
At 107 West Locust.
Now,
I'm sorry. Where?
107 West Locust, Laredo, Texas.
Got it.
And when at the time of his death, he was residing at that location, yes?
Yes.
And when did he die, sir?
It was February 11th, 2026.
And how old
I'm
was
sorry,
he?
February 11th.
February 11th, 2026.
Of this year, Judge.
He was 69.
Now, Judge, I know that I've asked the court to take notice of the filings, Judge, but that in particular, we filed an original death certificate amongst the records of the court. Now, the property that you've indicated where he lived, was that property that he owned?
Yes.
And is that the only piece of real property that he owned here in Webb County, Texas, or any other place?
Yeah.
Okay, and that property has an estimated value of over $50,000, is that true?
Yes.
And the will that I've indicated to the court that is filed amongst the records of the court is the last will of your father, correct?
Yes.
He never revoked that will or do anything to indicate to anyone that he was disavowing that will, correct?
Correct.
Now, there is a necessity to administer the estate of your father, is that true?
Yeah.
Now, up until the time of his death, the 4 children, and you indicated that he had with your mom, those were the only children he had. He didn't adopt anybody or have any more children after the death of your mom, is that true?
Yeah.
And their marriage was never dissolved prior to the death of your mom, is that true?
That's correct.
And in the will of your father, he indicated that he wanted you to serve as an independent executor. Is that true?
That's correct.
And sir, you are not disqualified for any reason from serving as the executor of his will. Is that true?
Yeah.
You've never been convicted of a felony over a crime or a crime of moral turpitude? Is
No.
that true? And so you're asking the court, well, there is no state or governmental agency of the state of Texas or any charitable organization that is named in the will of your father, correct?
Correct.
And your the will that was executed by your father was witnessed by two witnesses, is that true?
Yes,
And that is Mr. Carl M. Barto and Mrs. Susie Rodriguez.
that's correct.
And the document, the will is self-authenticated and self-proved by the signatures of these two people, is that true?
Yeah,
You're asking this court to accept your appointment as executor of the estate of your father and pursuant to his wishes in the last will and testament of your father, is that true?
yes.
Because I don't have anything else to present other than again, ask the court to take notice of the documents that I've outlined for the court's consideration.
Mr. Peña, in your dad's case, cause number 2026 PB 73202, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider admitting your father's will into probate. The court finds that your father passed away at the age of 69 on the 11th day of February 2026, but he left a valid, executed, and self-proved will that was never revoked, dated May 17, 2024. The court finds that there is a necessity to administer your father's will. The court finds that your father did not name the state of Texas or any charitable organization as beneficiaries or devisees. The court finds that you are qualified and you are not disqualified from serving. The court finds that you have complied with all of the requirements necessary for the court to grant your request. The court grants your request, admits your father's will into probate, and will cause letters of testamentary to be issued out to you. The court has signed the proposed order filed by your lawyer. The court is tendering the original to the clerk's office. The inventory on your father's case is due to the court on or before November the 10th at 2 p.m. Is there an oath for Mr. Peña to sign?
Yes, we file the same amongst the records to the court and here it is. And we're tendering it back to the clerk.
That concludes this portion. The court has granted your request. Mr. Peña, do you have any questions for the court?
No, thanks.
I wish you well, sir. You have the court's condolences. Any other cases for Mr. Reyes?
That's all I have for today, Judge.
That is all.
Good
to
seeing
see
you,
you.
Judge.
Likewise. Yes, sir.
Next in person is Counsel Roderick Lopez, page 5, number 13.
Macy Perez versus Cornerstone Fitness, Texas LLC, DBA True Athletic Clubs, cause number 2025 CVF 2302C3. Good afternoon, Mr. Lopez.
Good afternoon, Judge.
Court martial present in person.
Thank you. They have filed an answer, Judge, so that moots our motion for default judgment. So I just wanted to advise the court. I think there was a Rule 11 also that
Yes, sir.
should have been filed as well as the answer.
That is right. Let me just get confirmation. Macy Perez, party Macy Perez, lawyer Dalby Fleming. Or any other person present on this case? Court finds that no other persons are present. The court did receive the Rule 11 agreement to not go forward on this hearing, which is a bench trial. Nothing indicates, I think I didn't see it, how much time is being requested.
We probably need to enter into a guideline order, Judge. We are also in kind of talking about getting the case settled, so.
Well, I tell you what, I'm gonna set this then for a docket control conference, and the only requirement at a docket control conference is that the parties enter a pretrial guideline order. So you can announce settlement then, or you can file an agreed to pretrial guideline order, or you can come to court and I can give you some dates, whichever one works best. But for that docket control conference, do you think 30, 60, or 90 days would work best?
More than adequate.
All right, give us a docket control conference in approximately 30 days or as close to 30 as we can.
Yes, my next available, Your Honor, is October 6th at 2 p.m.
If you need any relief from the court, just file it in writing and we'll give you an earlier setting.
For the record, we're canceling the date for August 18th, Your Honor.
Yes.
Thank you.
So it's October eighth,
6.
6 at what time? Okay, for DCO. Okay, that's all I have, Judge. Maybe.
It's good to see you, Mr. Lopez. Have a good day.
Take care.
Your Honor is Counsel Claudia Lanese Garcia, page 4, number 9.
Looks like these are companion cases, page 4, cases 9 and 10. The estate of Edna Carranza, cause number 2026 PB 718L2, and the estate of Henry S. Carranza, cause number 2026 PB 735L1. Court marks Ms. Claudia Garcia present in person, Mr. Francisco Tames present by video conference, Mr. Marcel Knotson present by video conference. Are you Denise Bunk?
Yes, I am.
Welcome to court, Ms. Bunk. The court marks you
Thank
present
you.
participating by video conference. For the record, Bruce Warstack, Maria Elena Montemayor, Marta Cigarroa, Carlos Flores, or any other person, Mary Jane Thompson, any other person, witness, litigant, or lawyer present on these cases. Court finds no other persons are present. Ms. Garcia?
Your Honor, with regard to the estate of Edna Vernet Carranza, both parties filed their respective orders regarding the mediated settlement agreement, Judge. I believe they're slightly different in different respects. I know that we requested the transcript of the hearing just to make sure that we were fully accurate, but we haven't received it yet. So we filed ours as we recollected with regard to our notes. So there are two different orders submitted. They're e-filed and I believe both uploaded to case lines.
Any
And
other
Ju-
announcements, any other announcements on the L2 case?
Just that.
Judge,
So
Uh,
give me 1 second,
Okay.
Mr. Knotson. Ms. Garcia, you said that the differences are just slight. Tell the court what your proposed order is and what the slight difference is.
From what I read in Mr. Knotson's, any actions that Ms. Bunk is supposed to take in favor of Ms. Montemayor are not going to be done until and unless they receive the full payment of the retirement funds that Ms. Edna Vernet Carranza had. My client complied with the agreement to provide all correspondence that she's received and an affidavit, a sworn affidavit as with regard to her knowledge, with regard to those accounts. My client had no access, no knowledge other than being in possession of a letter from the investment company. And so we would say that my client's receipt of a deed with regard to the Chihuahua property, an assignment of or a stock transfer agreement should not be dependent on whether or not they get the full amount that they're expecting. My client has no information as to how much was in that account and never accessed it, never had the authority to access it, but most importantly, never attempted to access it. So the agreement was my client gets 50% of the Chihuahua property and the decedent's 50% interest in the stock. It's not dependent on whether or not Ms. Bunk and her brother receive the full amount they believe is on deposit with their retirement account.
Okay.
That's number one. Number two, when it comes to transfer of title, my client needs a warranty deed, even a general warranty deed, not a quitclaim deed. So Mr. Knotson had put in there that he would only provide a quitclaim deed with regard to the Chihuahua property, and that is not proper. Ms. Bunk and Mr. Nixon received in June a warranty deed from the estate for the property that they are getting, the Surrey property, and so my client needs a warranty deed as well, not a quitclaim deed. Those are the major differences that I saw, Judge.
Mr. Knotson, go ahead.
yes, number one, Judge, in good faith, we sent yesterday afternoon our proposed documents to them. we didn't get that same courtesy. We got them when they were filed at 12 noon today. So my clients reviewed it, and there are not a few, there are some major differences, Judge. And this is the first time I hear my client when so I sent it to them maybe about 1 o'clock, and they're like shocked. We agreed to a settlement agreement, mutual release, and we heard if the court can tell us who is the one that the court reporter that transcribed it, as the court knows, when did they request that? We should have been notified. So I was going to ask to reset this because I think everyone needs to get the transcript before anything submitted. Parties should have time to file objections. And when we have a settlement, Judge, it's not like, oh, okay, a trucking accident case. Well, you dismiss it with prejudice, Ron Rodriguez or Thomas J. Henry, and then, you may get the settlement check later from the insurance company, but you give the trucking company a full release. We have nothing to do when they write checks. Here, Judge,
Let me ask you about specifics to this case. The court has heard some differences.
Judge, I have others.
Perhaps in language or perhaps of opinion, but tell the court what the substantive and actual differences between the two proposed orders.
Okay. The main one is, Judge, that the consideration that we were giving is, number one, we were giving 50% of the community's interest in the Chihuahua, I believe, which is 25%, is going directly from from Burnett Carranza to Maria Elena directly. So she's going to directly now own 75%. She's
If I remember correctly, and I think you might be right there, but wasn't the settlement terms that it goes into the L1 case, the estate of Mr. Carranza, or is
Right.
that a different provision?
Yes, that was the Mr. Carranza's 50% that he owns. The other 25% goes into the estate. You have a very good memory, Judge, and you are exactly correct. Also,
What other substantial differences are there?
also, same thing with the THSSI. My clients, Burnett's 50% in THSSI is going to Maria Elena in consideration for receiving from Maria Elena. Basically, it's about 467,000. We attached Exhibit A. We attached Exhibit B. It's the Capital Fund and Jefferson Fund. As of June 30th, the Capital Fund, let me see this, was, and it's attached to my settlement agreement, as of July 30th, 2026, and it has the account number 40052045528. So it's only been like a month and 5 days, 409,689.75. And I believe we announced on the record, if it's gone down in value, well, whatever's there August 5th, that's what we're going to get. If it's gone up in value, that's what we're going to get. So
where's the difference of opinion?
So basically, based on what they submitted, I have no confidence with, and they're not saying they're going to pay. So basically, there's no consideration. Basically, here, this account, as the court knows, it shows the name of Burnett Carranza, Henry S. Carranza beneficiary. So just so we're crystal clear, I want to make sure there's no shenanigans by Miss Montemayor that, oh, well, there's nothing in that account now because I was the designated beneficiary under Henry or whatever. And, I do not believe for
But-
one
but
minute.
what's the answer? Is it funded, not funded? Is it there a dollar, 100,000? What's the
She had a
answer?
power of attorney from when my client died.
But do you know the answer?
All we know is this is what we got, and this was the exhibit A, that, exhibit number 1
Well, it
that
sounds to
I
the court
marked
that if
and
no
attached
person,
during the settlement hearing.
it sounds to the court that if no person knows the answer, then the best outcome for all parties involved is for the court to sign one order or the other.
No,
That way, the settlement is fully effectuated. And if there's anything improper, then you can come back to this court in the same hearing and ask for an enforcement. So
And
I think
Judge,
the court
Judge,
heard- give me one second.
I'm
I
not
think
done
the court
yet.
Heard from Mr. Knotson.
I'm not
that-
done.
I understand that Ms. Montemayor had filed her proposed orders at noon today. Mr. Knotson, has Ms.
need more
Bunk
time.
filed hers?
What?
Has Ms. Bunk filed hers?
Yes, we did.
Okay.
But
so the
it's a
court had-
settlement agreement. They're doing it as a proposed order.
The orders are due
There is
today.
nothing in the agreement that says we're just going to submit an order. We signed a
The-
settlement agreement first. We get the funds, and then there is an
No.
order.
No, the court put this on the record. The purpose
Yes.
of our hearing today is for orders due. The court was very clear and explicit that the only purpose for our hearing today was to receive one order and to sign off
Good.
on it by agreement. Or if there is no agreement, then the court would receive one, receive the
Yeah.
other, hear the differences between the two, and then contemplate which one most closely resembles the agreement. And if they don't either,
Yeah.
then the court will prepare its own based
Okay.
on what was put on the record.
Judge,
Mr.
may
Knotson?
I? Thank you.
Yes, sir.
And if I can just have time, number one is, this doesn't give us enough time to raise any objections to the proposed order. We should at least wait. Who did the transcript? We need to know that. We need to get the transcript to look at that, to be able, even they acknowledge that they ordered it. I didn't get notice that it was ordered. That is
Ms.
improper.
Garcia, have you or anyone else that you're aware of received a transcript?
No, sir. We requested it last week. I
From
understand.
who?
It's on
Go
the
look
court's.
The website and follow the instructions of the court that's listed on the website. We did that. I do know that we've reached out to Ms. Gorey today to request expedition on that. But that's all, we haven't received it, Judge.
Well, look, folks, so we've complied, right? You all have complied with the court's instructions. That's if there is no agreement as to what those proposed orders should look like, then file them both. I think Mr. Knotson said that the court has a good recollection. It wasn't that long ago. I know exactly what
Yeah.
transpired. I will be able to see which one is correct, which one is incorrect, and if
Judge.
we're both wrong, at some instance, court will prepare its own, but at least the court has
Judge,
the benefit of those two templates. Mr.
may I,
Knotson?
Your Honor?
Yes, sir.
Please, thank you. I appreciate that, Judge. Just so we're crystal clear, Judge, number one is my client was conveying that specifically to be able to receive, and you know this, Judge, and we'd ask you to take judicial notice of it, that they're going to receive, when she was alive, the funds, which was $409,689.75 as of a month ago on June 30th, 2026, subject to market fluctuations. In addition, my client is to receive on Exhibit B that I attached from Jackson Life Insurance Burnett as of January 20th, 2026, $57,975.48. That is, there has to be a mutual settlement agreement. They agreed to sign a settlement agreement of any and all claims, and you're not giving us a chance to get the transcript to do that and to do it without your own being able to review that. Number two is on the first page, Judge, the judgment declaring heirship is vacated and set aside. That was not announced on the record 100%. And, that is bad faith on their part. Number two, the next paragraph, that the order granting amended application for letters of administration is vacated and set aside. That is in bad faith. That was not ordered by Your Honor. That was not agreed to by my client. It was to be converted to upon receipt of the consideration. How can this occur if there's no consideration? They need to say that they have represented to this court, Ms. Garcia, that they have no knowledge of the 409,000. She has not had possession of it. And it's not gone to anyone else. And the 57,000. That's what they've represented to Your Honor. That's what the consideration my client's going to receive. If for some reason that, oh, well, that's no longer there, then there's a failure of consideration. There's no meeting of the minds at the mediation, and there's no settlement. That is expressly conditioned that my clients get that. We want to know, when do they expect to have that consideration? My client attached a document, Exhibit C, which is from there that she has to sign to where they were transferred over to my two clients. So it's very simple stuff, Judge. And there's no reason in the world to rush this. We should get the transcript. There's no urgency on this, and I'd like to see if my client has anything to say, but those are the two main things. The other thing is, that the motion or rendered moot, that's fine. They're saying that it's my client's automatically, without receiving the consideration, is a dependent administrator. That's the other difference. They're also saying she's not signing the full and complete indemnification. The one that we have there is basically, and it only has Texas Health Staffing Services, Inc. It was also Maria Elena Montemayor individually to the extent provided by law. She's been the one exclusively in control since my client died. My client hasn't controlled anything. So the last thing is, it shows that the interest, all right, title and interest to the real property is, Henry Carranza on the condo that burned down.
For the record, oh, Mr. Knudsen is back. Let me spotlight that video.
Okay.
that's on.
Yeah,
Go ahead,
I
Mr.
apologize, Judge. Okay, that one, my understanding is that Henry Carranza's 50% community interest was being transferred to the estate of Henry Carranza. Here it just says all right, title, and interest. As the court recalls, my client was going to keep that because she wanted to give her 50% to Mary Jane Thompson. So, and, so that's to the extent, that's the big, if they're saying, oh, it's 100% in that is wrong. Only Henry Carranza's 50% community property interest was being transferred to the estate. That needs to be clarified. And the other is being kept by Denise and John Nixon, Denise Bunk, John Nixon. And they're saying the jointly titled PNC accounts, are not in dispute, not under court supervision, but my client needs to receive. How can we do that without receiving, it's 409-689-75, and it's, I trust Mr. Carlos Flores to state where are these funds. He's a very smart, honest lawyer, and we need to know where these funds are. Have they been received by anyone? They've never found out where they are. So I want to be crystal clear on that, and that there's not any hiding the ball here with the court, nor with my clients or anybody.
Judge
So,
Mr. Flores, I see that you have recently joined us. Would
Yeah.
you like to be heard on this matter?
Yes, Your Honor, if I may. So I don't disagree with Mr. Knudsen in concept, which is that all the parties would benefit from having a complete copy of the record of that day in order to be able to finalize the order. I think that's correct. It is not our intention by any means to add anything to this order that goes beyond what the agreement was. But at the same time, it is also not our intentions to allow anything to be renegotiated of what was agreed to by the parties. My preference would be to have a copy of the transcript and base the final proposed order based on that. I know that Mr. Tames's office requested it several times. We were not able to obtain a copy of it prior to the drafting of the document. What we filed this afternoon or this morning was that a proposed draft based on our understanding of what transpired in the hearing. Are there things that may be clarified or modified? Of course, as is with every order which you're trying to enter into an agreement. It is not our intention to misrepresent anything, and that's why we're here.
Thank you.
But also, Judge, it is not an opportunity to renegotiate what was clearly stated in the record.
And we're not requesting to do that, so I'm just telling you my recollection and what my client and the judge knows that my client was going to receive what her mother had in those two accounts when she died, that those funds would be transferred to my two clients, period.
If I may just finish, Judge.
Go ahead.
My final comment, Judge, is that of course, we'll follow whatever the court wants. If Judge, if you feel that you can take our document and based on, your recollection, revise it and edit it and whatever the court wants to do, obviously we will follow, no question. But I do think that to have this venue at this moment to negotiate or discuss what it is or is not, I think would be more helpful to be guided by the actual record itself, and then have proposed red line revisions based on that. But of course, we'll do whatever the court. I'll do whatever the court wants, and I also defer to Ms. Lanese if she has a different view or wants to add on my comments.
If I may.
I agree
just-
with Mr. Flores too.
couple-
Ms. Garcia?
There are only a couple of things that I disagree with. Well, many things I disagree with Mr. Knotson, but I do need to put on the record, Judge. Number one, it was our understanding that Ms. Burnett Carranza's full 50% community interest in the Chihuahua property was going to be transferred to our client. Number
Nope.
two, when there is another property that Your Honor will recall in Bexar County, that is a condominium that burned to the ground. The parties agreed that Burnett Carranza's 50% community interest would most appropriately be transferred to the estate of Henry Carranza. That was what the agreement was. So no individual person is going to get Burnett Carranza's 50% interest. And I think what Mr. Knotson is forgetting about is that Burnett Carranza's estate can only transfer what Burnett Carranza's estate is entitled to. And that's 50% of the community interest. Henry Carranza keeps his 50% interest. The estate of Henry Carranza keeps 50% automatically, no matter what this court does. Well, the estate of Henry Carranza keeps its 50% interest in the community property. That's what I need to clarify. And I
Yeah.
completely dispute that, as I mentioned, my client does not and never has had her hands on any money that was Burnett.
Where is that
Carranza's
funds? Does she
Mr.
represent?
Knotson,
She doesn't
Mr.
know where they are?
Mr. Knotson, please don't interrupt. I'll give you a chance.
I apologize.
There's an investment company. My client doesn't have access to that. Ms. Bunk does. The other thing that I disagree with is that the letters of independent administration do need to be vacated. Absolutely, because this court is making Ms. Bunk a dependent administrator pursuant to the party's agreement, Judge. And that needs to be done. And Mr. Knotson's mediated settlement agreement only has her as administrator, which is also a bit deceitful because you have to be very specific in letters of administration. It's either dependent or independent. If you turn that into a third party, they're going to assume it's independent, Judge. So it needs to say dependent because we need to make sure that whoever receives those letters of administration for whatever reason know that. And that's all I have, Judge. And I agree with everything Mr. Flores said. I prefer to get the transcript to make sure everyone is on the same page, but I do need to make those corrections because as the court very clearly recalls, Mr. Knotson was very confused when we were reading it into the record and we had to do it a second time.
Mr.
Judge-
Tamez, I'm gonna acknowledge your presence once more. I acknowledged it when the court first called
He-
this case. Would you like to be heard on this matter?
No, Your Honor, I'm not a counsel of record on this matter.
Understood. Final word, Mr. Knudsen.
Yes, Judge. The court knows and, the parties agreed to the settlement conference. And, here Henry Carranza owns 50%. That was, to the extent necessary, going to be transferred. The court knows my client wanted to keep that 50%, was going to stay in her estate, the mother's, and she, out of the kindness of her heart, was transferring that to Henry Carranza's daughter. And that was even the subject of we went to mediation with Allison Haynes on the other one. She said should have been a full day, and I have a continuance on that, Judge.
Well, so
And
I haven't moved
Right.
on to
So-
that one. So let's stick to
So-
L2 and then we'll move to L1.
So basically here, Judge, we agree it is a dependent. My client agreed to that, but my client has to get those funds. And I think both counsel, they've represented that they have no idea where those funds are at. So I think by the time we get the transcript, I agree with Mr. Flores on that. I agree with Ms. Claudia Garcia Lanese on that. And my clients want that and, maybe reset it. Hopefully Donna Gorey should have that within like 2 weeks, I would imagine. That's the standard turnaround time. And I never got notified that a copy was ordered and that we reset it for 30 days. And there also has to be a settlement agreement that specifically has the indemnification language complete with regard to THSSI, which was the main concern of my clients and the reason this was entered into, which theirs does not even attach any settlement agreement, and the consideration must be paid. It's undisputed. There's 467,000 as of, when we entered that agreement. It was referenced in the announcement on the court. And, someone has to know where those funds are, and my client has to receive those funds. But thank you for allowing me to put that on the record, Judge. I appreciate that.
What the court's going to do in the estate of Edna Carranza, cause number 2026 PB 718L2, and Mr. Knudsen, Ms. Garcia, Mr. Flores, Ms. Bunk, I do this not only in the interest of justice, but I do this recognizing that it was absolutely crystal clear in this case that both parties wanted the exact same thing, and that is finality. Each side was pretty adamant that they wanted a full closure and conclusion, and they expressed that in different ways. But it sounds to me, and the other thing that I think I should put on the record, and I did put this on the record, is that I tried very hard, and I think I did speak very plainly in plain English about what the terms of that agreement was without going into much legalese. So it's pretty crystal clear to the court what the agreement is. So I tell you what, this is what the court is going to do in the interest of justice and keeping in mind the goals of both Ms. Bunk, her brother, and Ms. Montemayor. I am going to order the parties, if they choose to do so, they don't have to, you're allowed to file objections until August 13th. And then what this is indicating to the parties, can't hold the court to it, but the court then intends to either sign an order or to prepare its own on August the 14th, more or less. That gives you about 30 days. If you want to use that time to receive the transcript, to see what is different, if anybody files a motion to reconsider, a motion to set aside, a motion for new trial, whatever you want, you get to come back and argue those same points again, but with definitive, crystal clear language about which of the orders is most correct and so forth. Ms. Garcia, questions on this?
No questions, Your Honor, just that we would ask that the order, whichever one it is, one of the parties, Your Honors, that it does get entered and signed on the 14th with specific deadlines on as to when transfers of title, transfers of stock need to be done. And I'm putting it on the record that THSS needs to renew its license, and it has a deadline in mid-September to initiate that, Judge.
That's why I think I said you can't hold the court to it. That's the court's optimistic goals, but there's a good chance Mr. Knotson or you are going to file a substantive objection that's going to make the court reconsider many things. Mr. Knotson, go ahead.
Yes, Judge, thank you. And I would just say, I agree and with what Your Honor said, the framework, but I disagree on a hard date without knowing when. I think if your court coordinator could contact Donna Gorey, when will that be distributed to the parties and give us 10 days thereafter, I think is fair, just, which both parties agreed to be able to look at that so we can file objections. How can we file objections if we don't have the transcript? And if the court enters an order that is not in conformance with that, I mean, we can always do a motion to set aside whatever, but they have it as, you know, how it's undisputed. My client was going to get the consideration of the funds of those two accounts. They haven't identified how much are they aware in those two accounts. They're not requiring that those two accounts be paid, and that is unheard of in any settlement. And I don't know how that's fair, honest, or whatever, Judge. And if it's, you know, that was crystal clear.
Understood.
And I'm sure
any new argument before we move on?
Judge, I
Not yet, Mr. Flores. Let me just confirm that Mr. Knotson doesn't have any new information to put
yeah,
on.
and I appreciate, Mr. Flores, that consideration needs to be paid, and we just need to find out.
Anything else? Any new argument?
Go
Mr.
down
Knotson?
to 100,000, well, so be it. Or if it went up to Judge.
Mr. Flores, go ahead.
Yes, Your Honor, the only thing that concerns me is the motion for new trial, which is scheduled for this today, which was scheduled originally for today at this time. If there isn't an agreement on the status of the estate's administration, then the court, that will run out of time. I guess that is why Ms. Garcia is talking about this August 14th date. So I would ask the court to consider the following would be to, I guess, sua sponte, grant the motion for new trial without getting into the particulars of what that order would be, but allow the court to have plenary power beyond the 14th of August.
And Judge, what is don't you have, if the 75 days expires today, don't they have 30 days from today? So that shouldn't be an issue.
If an order is entered on the last day, then you get an additional 30. I see the issue. And if there's no signed order, then the time doesn't continue.
Oh, I thought when it's overruled by operation of law, Judge, if no order is entered on the 75th day,
Well,
it is denied, but it can be.
I tell you what, look, in the interest of justice, why doesn't the court just sign an order granting the motion for new trial, acknowledging that the parties have settled this and pending full final orders on that settlement? That effectuates
And
the parties'
Judge,
agreement, does it not?
Yes, sir.
I would have Mr. Lopez, who's very knowledgeable, research it for Your Honor. If today is the 75th day, I am almost positive that it's overruled by operation of law. You still get, that's the 105 days we all learned from law school. 75 days, there doesn't have to be a signed order in effect. If it's overruled by operation of law, you still get 30 days to grant it or change your order or whatever. That's my understanding of the law, Judge, and I think Mr. Lopez would agree with that. He probably knows that off the top of his head.
All right, moving on to the estate of Henry S. Carranza, cause number 2026 PB 735L1. Court again notes Ms. Claudia Lanesa Garcia present by video conference, Mr. Tames present by video conference, Mr. Flores present by video conference, Mr. Knudsen present by video conference. Any other parties, witnesses, lawyers, anybody else present on this case?
Mr. Flores is not an attorney of record in the estate of Henry Carranza, Judge.
Understood.
Judge, may I be
Um,
excused from the hearing?
Have a good day, Mr. Flores.
Thank you, Judge.
Counsel, what is the announcement on this case?
Well, Your Honor, we're a little bit shocked and disturbed. Mr. Knotson filed a motion for continuance on Friday, July 31st, stating that he had a vacation letter that neither Mr. Tames and I ever received. But it did state and demonstrate that he was going to be out beginning today or yesterday, Judge, for the delivery of his grandchild. And I'll be honest, my initial reaction was to oppose it. But Mr. Tames and I agree, as is the court's perspective, I guess, that the golden rule should apply in these situations. So I would not, in good conscience, be able to oppose a motion for continuance when another attorney is asking to be excused for the purpose of being present for the delivery of a grandbaby. Now,
Thank
I'm
you.
shocked that Mr. Knotson isn't by his daughter's side anticipating the birth of his grandchild and is instead in court, and I understand, in the middle of a mediation with Judge Maldonado. It leads me to believe that there was lack of candor to the court in an effort to postpone this case. We were set today for temporary administration, special exceptions, and a motion to compel. The temporary administration is very important, Judge. And we were going to ask for a very short continuance, a week possibly, because my client does need authority in order to be able to request the renewal of the license and actually have some court order authorizing her to manage the company, because there is none at this point. And so Mr. Tames and I are a bit disappointed that Mr. Knotson was not fully transparent about that. And he's in Laredo. He's present. We could have had a hearing today. And we were willing to give him that pass so that he could enjoy and not have this contested hearing on the day that he was going to be by his daughter's side. So we were under the impression that this was not going to go forward. We didn't expect Mr. Knotson to be at this hearing, much less be in town. So we were going to ask for a short continuance with regard, a short reset to next week, maybe the following week, to be able to get these motions heard, especially the motion for temporary administration. There has been no administration in this estate. Dr. Carranza passed away in March of 2026, and we're months in, and we do need someone to be in charge until all the contested matters are resolved, Judge.
Mr. Knotson, response?
Yes, Judge. First of all, I greatly appreciate counsel's accommodation. I was my flight's leaving later today, and that's why I was here to argue this, and also for the hearing on the child is my grandson's scheduled to be delivered tomorrow by cesarean section tomorrow. So I appreciate that. Also, they should have advised the court. We went to mediation with Allison Haynes, and she recessed it. She was going to give us homework to do that. The parties have a lot of information they need to provide to her to have a productive, fruitful mediation. Then, after a couple of days after the mediation, late last week, the issue came up. They need to renew the license. So I suggested to Allison Haynes a temporary administration for the sole purpose of her renewing the license. It shouldn't take more than 30 days and also, I also agreed to running the business, that she had all those full authorities. So I did agree to that. And so I think I was extremely accommodating and even thinking outside the box. My client, Mary Jane Thompson, doesn't want to keep this. I think it would be extremely helpful if Your Honor's available next week. My client will come down, or by Zoom. We're willing to do a settlement conference with Your Honor next week. And I think you could get this done and completely settled. And they will have 100% of THSSI, 100% of the Chihuahua Street, and basically, I don't want to mention what we offered in settlement, but we sent them the day before a settlement proposal before Ms. Haynes, so they had enough time to digest it, whatever. And basically, literally, we used half a day. They asked that it be reduced from a full day to half a day. And Ms. Haynes said that that was not enough. If you don't have time next week, but next week, I'm sure they want a broad, if it's limited here, what's the urgency? Renew the license. I agree with them. They can have that authority. And to run the business, I agree with them. They can have that authority. So if, basically, and then we can do a settlement conference with Your Honor next week or the following week and maybe get this whole thing settled. I'm willing to do that since they were accommodating to me, and I appreciate that again. So I don't think there's a disagreement. I just don't want it a full blown, but I want it without prejudice to my client's rights. They need to get it renewed, especially if she wants to keep it. Mary Jane is willing to let her have that as part of a settlement. She's willing to let her have the Chihuahua Street as part of a settlement.
So keep settlement communications at settlement.
No, I'm just advising the court.
Don't do that though. The court has heard from Ms. Garcia. A non-opposition has heard from Mr. Knotson. Mr. Tamez, and you should be heard if you so wish. Remind the court, was it you that filed the special exceptions?
Yes, Your Honor. Both the
So
special
what-
exceptions, I'm sorry, Your Honor.
So question, what effect, if any, does this continuance have on those special exceptions? How do they interact?
It's more than anything, it's a delay, Your Honor. We were here in the Burnett settlement where by agreement, the parties put the special exceptions, motions to compel, discovery responses, and the application for temporary administration set for today. We prepared accordingly. And that takes a lot of time and resources that our client is paying for us to prepare. Put aside everything that counsel has said regarding settlement. As Your Honor perfectly states, that is not before the court, and those conferences are confidential. We're here today because the parties agreed to hear these matters in litigation. Now, as Ms. Lanessa Garcia pointed out, and I agree, if counsel legitimately had a request for time off, we respect that. But the fact that counsel is here present today, to me, is a misrepresentation, not only to you, but to us. Rule 13 points out, Judge, that attorneys who shall file any fictitious pleading in a cause for such a purpose, or shall make statements in a pleading which they know to be groundless and false for the purpose of securing a delay of the trial of the cause, shall be held guilty of contempt. Despite what Mr. Knotson points out in terms of his ideas of what he can coerce and force in a settlement, we have spent, and our client has spent, considerable time in preparing for these motions to be heard. That is litigation. And Mr. Knotson's filing has delayed that.
Correctly, she does not oppose the continuance of the temporary administration. I believe the request was 1 or 2 weeks. Mr. Tamez clearly opposes continuance of the special exceptions. Mr. Tamez, argument?
Yes, Your Honor.
Okay.
The special exceptions have been filed, Judge, because they are vague as to what Mr. Knotson is claiming is the violations from our client in the operation of the business. And if you can allow me just 1 second, Judge, to open up the pleading. Your Honor, the Ms. Mary Jane Thompson's opposition mentions that she objects that Mr. Carranza's will should be probated. And in the opposition, she claims numerous times that Ms. Montemayor is not qualified to serve as executrix because she violates certain regulations. And he doesn't identify, Ms. Thompson or through her counsel, don't identify what specific federal, state, or local regulations they claim disqualify Ms. Montemayor from serving as executrix. And so as I pointed out, Judge, in my special exceptions, for example, in special exception number 1, Ms. Thompson, through her counsel, claimed that Ms. Montemayor is unsuitable and disqualified from serving as executrix. This is a general demur. It is not allowed by Texas Rule of Civil Procedure 90. It is vague and obscure and does not list the particular grounds that render Ms. Montemayor unsuitable to be an executrix. Counsel should be ordered to plead what specific grounds make her unsuitable to serve as executrix. Special exception number 2.
I'll agree to that, Judge, to accommodate Mr. Tames. I'll agree to that.
Special exception number 2. Ms. Thompson, through her counsel, claimed that Maria Elena Montemayor had a power of attorney for Henry S. Carranza after his wife's death on July 19th, 2025 until he died. This is an objection that is similarly vague and obscure. Having a power of attorney is not itself disqualifying. This is a general demur which is not allowed by our rules and therefore is vague, uncertain, and obscure. How this alone or in combination should disqualify Ms. Montemayor to serve as executrix. Ms. Thompson, through her counsel, should be ordered to replead and provide sufficient facts to support her allegation that Ms. Montemayor is disqualified from being executrix on the grounds of having a power of attorney.
Those are the 2 issues? And
that's just another objection.
Okay. Is he
Number
done?
Number 4, no, I'm not. Number 4.
Okay.
Ms. Thompson, through counsel, states Maria Elena Montemayor conveyed property to herself and or others from Henry S. Carranza and or the estate of Edna Vernet Carranza. Ms. Thompson, through her counsel, fails to identify how this allegation, even if true, was improper, what property was conveyed, when it was conveyed. Therefore, this is a general, vague, and obscure allegation on which Ms. Thompson, through her counsel, rely in their attempts to disqualify Ms. Montemayor. Ms. Thompson, through her counsel, should be ordered to replead and provide sufficient evidence to put Ms. Montemayor on notice as to what property was allegedly conveyed, when it was conveyed, and why that was an improper conveyance. The next special exception. Ms. Thompson, through her counsel, plead Maria Elena Montemayor ran a community business, THSSI, of Edna Vernet Carranza and Henry S. Carranza, and failed to comply with federal and state regulations to notify government of only license holder's death. And I'm sorry that doesn't read well, but that's a direct quote from the pleading. This ground to disqualify Ms. Montemayor is similarly vague and obscure. It does not state what federal and state regulations were allegedly violated. It further fails to specify which government was supposed to be notified or when or how it was supposed to be notified of the sole license holder's death. Similarly, it is vague and obscure how this alleged failure to notify the government, in quotes, pursuant to this federal and state regulation, in quotes, would render her disqualified. Ms. Thompson should be ordered to replead and list specific federal and or state regulations which she claims were violated, when they were violated, and how this renders Ms. Montemayor quote unquote disqualified from serving as the executrix of the last will and testament of Mr. Carranza. The next special exception. This is a quote from Ms. Thompson's pleading. Maria Elena Montemayor has failed to comply with federal and state law regarding changes in ownership laws for THSSI, therefore subjecting both estates to liability. Again, Judge, it is unclear what federal and state laws that were mentioned are separate from those mentioned in objection number 5. It is further not clear how these laws subject either state to liability. Therefore, this objection is vague, obscure, and too general to give Ms. Montemayor proper notice of the alleged grounds that disqualify her. Ms. Thompson should be ordered to replead and specify what federal and or state laws she alleges were violated and how this subjects Mr. Carranza's estate to liability, rendering Ms. Montemayor unqualified to serve. Special exception to the opposition generally. Separately, Ms. Thompson repeats these same allegations throughout her pleading, found in objection number 1, number 3, number 4, number 5, and number 6. In her pleading, making those portions of her pleading where she repeats those journal demurs just as vague, obscure, and defective. She should be ordered to replead, correct these defective pleadings, and specify with specificity what she is renders our client disqualified. We further, in our special exceptions, Judge, asked for the court not only to grant them, but then to give Ms. Thompson and her counsel 10 days from today to amend those pleadings and provide the specific grounds of our special exceptions.
Can I respond?
Anything else, Mr. Temes?
Not on the special exceptions, Your Honor.
Mr. Knudsen, go ahead.
All right. Okay, Judge, basically here, I agreed to, first of all, for all the special exceptions, I agree with 10 days, but I would ask when it be from Monday, which will be when I get back from Dallas, and my anniversary's this weekend on Saturday, August 8th, 39 years that my wife's put up with me. So that would be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, the 20th, Judge. What you do grant. Number 2 is, Judge, Texas is a fair notice, pleading. All we have to do is give fair notice. Generally, automobile accident, negligence, gross negligence, drinking and driving, those are basic. You don't have to marshal your evidence. I mean, this is basic law. We took all this up with, number 1, with Judge Hugo Martinez. This is the case where Marty Cigadroa was counsel of record. Her firm prepared this will. They admitted that, if they want me to put in, they admitted in discovery, they asked for time, the very last day that we were set for a hearing with Hugo Martinez, Ms. Cigadroa filed a motion to withdraw. Oh, there's a conflict. And she filed it the night before without any notice, which is typical. Secondly
I'm going to
is,
object to the sidebar.
Sustained.
Thank you.
okay,
Mr. Knudsen,
yes.
go ahead.
So here, basically, I told the judge, basically, here's a case. His only child and only 2 grandchildren, he basically disinherits all of them and leaves like $3 million to a friend, a stranger to the estate, a stranger. He was frail, Judge. They admitted in discovery he was taken in a wheelchair. They admitted that. Mr. Temes knows that. Ms. Garcia knows that because she was in the other case. Now, so number 1, basically, we don't have to marshal, but I can put information that we now have, but we requested to take her deposition. They have fought that, and they have prohibited us from doing that. we need to take her deposition, which we're entitled to do. And maybe Mr. Tames will be courteous to agree to a date. And I will even further illuminate within 10 days thereafter, supplement anything else, uh, so basically on number one, I'll agree to do that. I asked 10 days from Monday. If not 7 days from Monday, Judge. Number two is Maria Elena Montemayor had a power of attorney for Henry Carranza after his wife's death until he died. It's vague and obscure. In the other case that Ms. Garcia is counsel on is vague and obscure. They have a copy of that power of attorney. She has it. You know, uh, you know, is not itself disqualifying. I'm not sure it's a had a power of attorney after the death until he died. So, I mean, they know it's true. They know it's true. Marty Cigadroa prepared it and they have it. So talk about Rule 13, Judge. I don't want to go there, but that is, and Miss Garcia, Mr. Tames was not in the other case, but Miss Garcia was, and she is fully aware that they have the. What else do they want to know about the power of attorney when they have it? Miss Montemayor.
Your Honor, I think
had
it's
the-
clear on this point that the
Let me
question
let
is not.
Mr. Knudsen finish his thought. Anything else put on the record with regard to this, Mr. Knudsen?
Okay, that was on number 3. I think I don't understand what they're asking for us to do. I mean, I don't think I just found out after I did that on information belief, it was Marty Cigadroa that prepared it. And so they know that. And as an officer of the court, Miss Garcia knows that. And, basically he should withdraw that special exception. Number 4, conveyed property to herself. I will agree based on specific facts that I have within 10 days to either from Monday or 7 days from Monday to give me time to do that as to accommodate them. Number 5, but we also want number 5, that she ran a community business, failed to comply with federal and state regulations to notify the federal government of the only license holder. Again, they know, Ms. Garcia knows that we did, and the court knows that we did a brief and attached a memorandum brief of like 9 pages that sets forth all the laws, all the regulations. So they are specifically aware of that. And this is patent bad faith by Ms. Garcia because she signed it also, and by Mr. Tames. I'm not sure why Ms. Garcia didn't say, oh, Mr. Tames or Kiko, oh, we already got in the Burnett case a 9-page brief. So they have that. I mean, if they want me to include the 9-page brief in there, they already have it, or I'll attach it as Exhibit A, but that is bad faith. That is per se a violation of Rule 13, but I'm not going to move on that, Judge. So I would ask that objection. And Your Honor knows you had the memorandum, and that was specifically set forth, so that should be overruled.
Any other thoughts or new argument?
The last objection, Judge, failed to comply with federal and state laws regarding change in ownership. It's the same law, the same memorandum. That should be overruled. And on number 1, I agreed to. Number 3 was I think that should be overruled because they have it. It's in their control. We don't have that power of attorney. They have it, and it speaks for itself. Number 4, I will amend that by agreement within 10 days or 7 days from Monday. And 10 days from Monday or 7 days from Monday. And number 5, And number 6, we gave the regulations and those should be overruled. Thank you.
May I respond, Judge?
Mr. Tamez, go ahead.
Thank you, Your Honor. Yes, Judge. First on the power of attorney, the objections as couched and as articulated in the objection to our client serving as the executrix spell out why she should be disqualified. So the reasoning, and I got lost in listening to counsel, but his own objection, his client's objection say that our client is disqualified from serving as an executrix because there was a power of attorney. And I failed to follow, and that's where I want some specificity. How does having a power of attorney as an attorney in fact render a person disqualified? When under the law, a power of attorney is allowed. It's a instrument that we all use in our practice. And so what I'm asking for is if he is going to object on that ground alone, that he state why having a power of attorney disqualifies not only just the fact that it's our client serving as executrix, it was Mr. Carranza who chose to name her in his will. The testator's intent to name her as the executrix. And Mr. Knotson, through his client, is trying to undo that. And so what I'm asking for is, how does having a power of attorney in and of itself render someone under law disqualified to serve as an executrix? That's my response to his objection number 3.
Can I respond briefly?
If it's new information or new argument, absolutely.
Yes. Yes. Thank you, Judge. On number 3, and I'll be so kind to explain it to counsel where I think he'll understand it. Basically, if she had a power of attorney, and that's why we need her deposition, did she change while she had a power of attorney any of his bank accounts to a POD, payable on death at the bank? Under the law, as the court knows, and Mr. Tamez should know, is that there is a presumption of duress under the law. And those will be set aside, and that's bad faith, and that's a breach of fiduciary duty, and that entitles my client, as a matter of law, Mary Jane Thompson, to punitive damages, number 1. So that is one example, and that's why we need her deposition. And they can just merely say, you know what? She never named herself as officer of the court. He can state unequivocally she did not have any power of attorneys. She did not take him to the bank. She did not have him do that, and did not drive him there. So that's the answer.
In the estate of Henry S. Carranza, cause number 2026 PB 735L1, there are 2 matters pending before the court. 1 are special exceptions, and 2 is a temporary administration. There is a motion for continuance on file. That motion is unobjected to. The court will hear that on August the 18th at 2 p.m. With regard to the special exceptions, it is agreed to that special exception 1 and 4 it's agreed to. So let me do this. Mr. Tamez, do you have proposed orders on file?
I don't believe I did, Judge, but I can file it by today.
File it with the court. The court is going to sign off on at least 1 and 4. I'm going to re-review everything. Here's what I need all persons on this case to understand with whatever happens with these special exceptions. And I kind of foresaw this. That's why I was hoping to resolve both at the same time. But I think that it's very possible that because of the settlement that's happened in the L2 case may have impacted some of the proceedings now in the L1 case. And I'll give you some specifics, which is why I said if there's any other settlement discussions, probably don't put it on the record, or definitively don't let me know. But if there is agreements already as to state and federal regulations in the L2 case, then I think to some extent, any allegations here are either mooted, extinguished, or in some part diminished because of the admissions and settlement in the L2 case. So I am going to order that these special exceptions be provided to the court, the amendments there to be provided to the court on or before, I'm going to give Mr. Knotson more time than he's requesting, August the 14th at noon, which means that the parties will have a few, at least 1.5 business days before coming back on the temporary administration. Anything else for any person to put on the record with any new information, new argument, or new objections?
Your Honor, there was a motion to compel set for today that should be rescheduled to August 18th, Judge.
Not in my notes. I did see it in the request by Mr. Knudsen. Let me ask Ms. Noriega.
That's our request, Judge. It
And
was our
we,
motion to compel, correct, Mr. Tames, or am I confused?
Correct, that's our motion.
Well, I tell you what, nobody's urging it right now, and we're gonna come back on the 18th. Judicial economy says set everything at the same time, so ordered. Mr. Knudsen?
yes, I made a suggestion earlier. I don't know if they think it would be helpful. I would definitely be agreeable to a settlement conference with the court on the 18th. Which would hopefully resolve everything. But if they just want to have a hearing, and I've also offered to do the administration, so if they want to reach out to me when I get back on Monday to do an agreed order, I can do so beforehand, before the 18th. If it's limited to running the business in good faith and limited to anything she needs to do to renew the licenses, we have absolutely no problem with that. So, and if they want to think about it, settlement conference with Your Honor, that's the only additional thing I would ask them to let us know.
I very much, Mr. Knudsen, appreciate the vote of confidence in the court's ability. I have two concerns at this point. Number one, and I lost the first. The second being that Ms. Allison Haynes at this juncture is much more well-versed, much more familiar with the parties, the allegations, the background and such. So I would suggest.
Correct.
Oh, and the second concern is, even if I get you all there, Mr. Knudsen, Mr. Tames, and Ms. Garcia, I now know that it's very likely that the request for additional time for a transcript may be forthcoming. So I would rather that Ms. Haynes get everything reduced to writing and enter that document as part of the record. So I highly suggest, if the parties are available on August the 18th in the morning, see if Ms. Haynes is available on that date or before.
Your
Okay.
Honor, is that a court order or a suggestion?
Suggestion, I think.
Well, I'll put it to you this way. I'm ordering the parties to mediation with Allison Haynes, subject to her availability, before August the 18th at 2.
Thank you, Judge. That's fair enough. I agree.
Anything else on this case, Ms. Garcia?
No, sir.
Mr. Tames?
Just one quick thing, and I'd be remiss not to mention it. And the reason why I'm adamant about those special exceptions on the issue of rules and regulations. I've been in charge conference before where counsel have argued that the regulations have been on file in other documents. They need to be on file in the pleading based on the allegations that are being made. And that's why I'm so adamant on making sure that the pleading itself lists which specific regulations disqualify my client.
All right, Mr. Tames, Mr. Knudsen, Ms. Garcia, I'm confident that whether you realize it or not, you're very likely closer to the end than not. But I wish all parties well as they continue preparing for continued litigation and also for settlement. I
Thank
wish
you,
all
Your Honor.
parties well. Have a good day.
Thank you, Judge.
You too, Joe.
Is Donna Glory in charge of that transcript, Judge, so I can reach out to her?
Court will advise just to go to the website. All of the instructions are there.
Thank you,
Good day.
Judge. Bye.
Next in person is Counsel Garcia, Jonathan Garcia Davalos, page 1, number 1.
This is in the matter of Heriberto Delgado Reynoso, cause number 2024 CIG 17L2. Good afternoon, Mr. Garcia.
Good afternoon, Your Honor.
Court martial present in person. Vanessa and Bella, are you present? Court finds no other persons are present. Counsel, what is the announcement?
Your Honor, I was able to file the suggested form with the USCIS with the Immigration Department. And upon speaking with an immigration officer, I was informed that it takes about 8 to 14 months for the application to be processed. This is assuming that it gets actually accepted and everything
Oh my. And when was the application filed?
today.
Do you know the status of the well-being, health, emotional, physical, or otherwise for Heriberto Reynoso?
Last time I went, which was the last time that we had court, he was doing very well and I had communication with Ms. Bella today because I had to get the another form signed because I needed another form to be signed. And it seemed that he's still there receiving services, so.
All right. Well, Ms. Noriega, give us a docket control conference in December, our last setting in December. Well, maybe our first.
I guess if we can get 8 months, Your Honor, at least 8 months, because and this is straight from someone who just went through the course, I guess, giving stats about how long it takes. So it's 8 months, at a minimum 8 months.
This is in January, February. Give us that date.
January 14th at 2 p.m.
All right.
And I paid for the application fee, which is $450. I know that there was the court. I guess I'll ask for a reimbursement from the court.
Yes, sir. Well, if for whatever reason, there's any advancement in the case before January, please, just file an advisory or fiat or whatever. That way the court can keep abreast of any pending statuses.
Yes, once it's been accepted, the following step will be, I guess, giving it to the, I think it will be to the court staff, because because once it's get accepted, we can show proof to the Health and Human Services Commission that he's eligible.
Your Honor,
Yes.
if I may, I believe that was correct. Then once he qualifies for those benefits, our PCI, which is our probate court investigator, can submit that application through HHS.
So, yeah, once I get that, I'll go ahead and provide it to the court with an advisory that has been accepted and proved that there is one.
All right. I'll call this case on January the 14th. Any other cases for Mr. Garcia Davalos?
Number 7.
This is in the estate of William Harvey Nolan, cause number 2026 PB 72602. Court marks Mr. Garcia Davalos present in person. Are you William Nolan?
Yes, Your Honor.
Welcome to court, Mr. Nolan. Court marks you present by video conference. Are there any other parties, lawyers, or witnesses present on this case? Are you Arthur Nolan?
Yes, sir, I am.
Welcome to
Your
court,
Honor.
Mr. Arthur Nolan. The court marks you present by video conference. Any other parties present? All right, Mr. Garcia Davalos, what is the announcement?
Your Honor, we provided to the court the request that we're ready to proceed with the application to probate the will.
All right, Mr. Nolan and Nolan, I'm gonna ask that you both unmute your device and raise your right hands. Mr. Arthur Nolan, unmute your device. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do. Yes, I do.
You may lower your hands. Mr. Garcia Davalos, one witness at a time, go ahead.
Yes, I'll go ahead and commence with Mr. William Joseph Nolan. And so can you please state your full name, Mr. William Joseph Nolan?
Yes, it's William Joseph Nolan.
Okay, as to your identification, before we proceed, is that you reside at 14110 Freeboard Drive, Santa Fe, Texas, is that correct?
Yes, sir.
And that the last 3 of your social are 026 and the last 3 of your driver's license are 351, is that correct?
Yes, sir.
You understand that that we're here to applying so that you'll be appointed as or that you'll be designated as the executor of the will of your father. Is that correct?
Yes.
Okay. Now, as to your father, he passed away on February 21st, 2026 in Laredo, Webb County, Texas, at the age of 77.
That's correct.
And at the time that he passed away, he resided at 2663 Vineyard, Laredo, Texas, 78045. Is that correct?
Yes.
The last 3 of your father's social are 095, and the last 3 of his driver's license are 602. Is that correct?
Yes.
And in terms of his property that will be subject to the probate, to the administration of the estate, is that it's approximately, a real estate property, cash, personal effects, and or household goods of approximately $420,866. Is that correct?
Yes,
As to the will, he left a will that was never revoked and that is dated October 3rd, 2014. Is that correct?
yes,
And to your understanding, he never amended and made any changes to this will that was provided to the court. Is that correct?
that's correct.
And after he made this will, there were no children that were born or adopted by your father. Is that correct?
Correct.
And no marriage of your father was ever dissolved after the will was made. Is that correct?
Correct.
And in the will, he named his sons Arthur Thomas Nolan and William Joseph Nolan as independent executors. Is that correct?
Yes, that's correct.
In this will, there's no state, governmental agency, or charitable organization being named as a DYC. In other words, receiving a benefit from the estate of your father. Is that correct?
Correct.
And then this is a self-proved will that you're asking the court to accept, in which it has subscribing witnesses sworn in and notarized, and their names are Sylvia Lopez and Eliza Lopez. Is that correct?
That's correct.
And then as part of this will, there's no bond being required. And so you're asking that you be named as a co-executor of the estate of your father. Is that correct?
That's correct.
Okay. May I now proceed with the follow, unless the court has any questions?
No, Mr. Arthur Nolan, unmute your device and stay still. Go ahead.
Sorry, Your Honor.
Mr. Garcia Davalos.
Can you please state your full name?
My name is Arthur Thomas Nolan. I'm the second born of William H. Nolan.
Okay, and you understand that we're here to do an application to probate the will of your father. Is that correct?
That's correct.
And you reside at 2663 Vineyard, Laredo, Texas, 70445?
Yes, sir.
Okay, and the last three of your social are, let's see, 314, and the last three of your Texas driver's license are 637. Is that correct?
Yes, sir.
You heard the questions that I made to your brother in terms of the probate of this will. Is that correct?
Yes, sir.
And asking you the same questions, would you be answering in the same manner?
Yes, sir.
Okay. Now, just to, and I guess before, something that I need to add, you don't have any felony convictions and you qualify to be an executor of the will of your father. Is that correct?
That's correct. I have no felonies. Correct.
And you're asking that you be appointed as a executor of the estate of your father with your brother, William Joseph Nolan. Is that correct?
That's correct.
Okay. And Your Honor, I think I missed a question with Mr. William Joseph Nolan as to that he qualifies and has no felony convictions as well.
Go ahead.
Mr. William Nolan, just to clarify, you're eligible, you qualify to be an executor and you have no felony convictions. Is that correct?
That is correct.
And Your Honor, at this time, I'll be asking for the court to accept the will that has been provided to the court. And also that they be appointed or that they be designated as executors of the will of the estate of their father.
Mr. Arthur Nolan and William Joseph Nolan, in your father's case, cause number 2026 PB 726L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider admitting your father's will into probate. The court finds that unfortunately your father passed away on the 21st day of February 2026 at the age of 77, having left a valid, executed, and unrevoked will dated October 3rd, 2014. The court finds that your father had no children, none were born or adopted or were expected at the time or thereafter after the execution of that will. The court finds that the state of Texas nor any charitable organization were named in the will as devisees or beneficiaries. The court finds that there is a necessity to administer your father's estate. The court finds that both of you are each and both qualified and you're not disqualified from serving. For all of these reasons, the court hereby grants the request, admits your father's will into probate, and will cause letters of testamentary to be issued out to you. The court has signed a will, an order to that effect. The court is tendering the original copy to the clerk's office. The inventory on your father's case is due to the court on or before November the 10th at 2 p.m. Your lawyer will file your executed oaths as soon as possible. Anything else on this case, Ms. Noriega? Mr. Garcia, do
No, yeah, no, yeah.
you have any questions for the court, Mr. William Nolan?
No, Your Honor.
Do you have any questions for the court, Mr. Arthur Nolan?
No, Your Honor. Thank you very much, Your Honor. I appreciate it. Thank you, Mr. Garcia.
Yes, keep in contact with your lawyer. I wish you both very well, and you have the court's condolences. Have a good day.
Thank you.
Thank you. May we be excused, Your Honor?
Yes, sir. Yes, sir.
Thank you.
Thank you, Honor.
Any other cases for
No.
Mr. Garcia?
That would
No.
be the
It's good to
Yeah,
see you,
thank you, Honor.
counsel. Have a great Tuesday.
next.
Court will stand at ease momentarily.
one.
Court is back in session and we are once again on the record. This is the probate guardianship and civil docket at Webb County Court of Law 2 for Tuesday, August 4th, 2026. The time is now 4:11. Ms. Noriega, what is the next case?
That is with counsel, page 1, 2.
This is Brogo Transport LLC versus Interflet Brokerage, cause number 2025 CBD 44L2. Court marks Mr. Barrera present in person, Mr. Morris present by video conference. Are there any parties or witnesses present on this case?
Sí.
Speak into the microphone and tell the court your name.
José Mata. Ah, perdón.
Person in person, what is your name?
La persona en persona, ¿cuál es su nombre?
Armando González.
Armando González.
And which of the two businesses do you represent?
¿Y cuál de los dos negocios representa usted?
Brogo Transport.
Brogo Transport.
And are you Jose Mata?
Sí.
¿Es usted José Mata?
Sí.
Yes.
And which of the two businesses do you represent?
¿Y cuál de los dos negocios representa usted?
Interfleet Brokerage.
Interflet Brokerage.
Mr. Barrera, you were the plaintiff, slower than usual to allow for interpretation. What is the announcement?
We're ready, Judge.
¿Cuál es el anuncio, abogado Barrera? Estamos listos, su señoría.
Mr. Morris, what is your announcement?
We're ready, Your Honor.
¿Cuál es su anuncio, abogado Morris? Estamos listos.
Mr. Barrera, give the court a time estimate.
I would say slightly over an hour, Judge. Maybe an hour now.
Mr. Barrera, can you get closer to the mic? I cannot hear you.
Yes, I was saying my estimate would be slightly over an hour to an hour and a half.
Su señoría, mi estimado sería de 1 hora a 1 hora y media.
Mr. Morris, what is your time estimate?
I think about an hour and a half as well.
Abogado Morris, ¿cuál sería el estimado en cuanto a tiempo? Creo yo que 1 hora y media también.
Mr. Mata, I'm going to ask you a question and I'll let your lawyer advise you if you want to answer or not.
Señor Mata, le voy a hacer una pregunta y dejaré que su abogado le aconseje si usted debe de responderla o no.
In what city do you reside?
¿En qué ciudad vive usted?
En Laredo.
En Laredo.
Y sí permito que me aconseje el abogado, William Morris.
And yes, I do allow my attorney to advise me.
Let me ask our interpreter if both were present in person, can there be a three-way call for simultaneous interpretation?
Yes, Your Honor, we could try to do it right now as well.
It certainly was not the question. All right, Mr. Morris, Mr. Barrera, get the phone numbers for each of your clients and provide them to the court. We're going to do this with simultaneous interpretation. If for whatever reason the muting becomes an issue, then I'm going to reset you. You're going to have about an hour, probably a little bit more than an hour today. So use your time wisely, Mr. Barrera and Mr. Morris.
Thank you, Your Honor.
Okay.
Stand by.
That would be counsel Cassandra Bonilla. And she is on page 5.
In the matter of Jennifer Jenny Maldonado, cause number 2025 PB 666L2. Good afternoon, Ms. Bonilla.
Good afternoon, Your Honor.
Court marks you present by video conference. Is there any other parties or witnesses or lawyers present on this case?
Good morning. Good afternoon, Your Honor. Bruce Warstack. I'm the ad litem.
Welcome to court, Mr. Warstack. Court marks you present and also participating by video conference. Counsel, what is the announcement?
Yes, Your Honor, we are ready to proceed with the application for guardianship. And I also have Miss Maria Lamont here, who is the HHSC guardianship specialist in this case.
Are you Maria Lamont?
Yes,
Ms. Bonilla, is Ms. Lamont the only witness in this case?
Yes, she is, Your Honor.
Ms. Lamont, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
You may lower your hand. Ms. Bonilla, go ahead.
Thank you, Your Honor. First, I'll ask the court to take judicial notice of all documents that have been filed in this case, including Exhibit A, the determination of intellectual disability, Exhibit B, the guardianship specialist affidavit, and Exhibit C, the APS affidavit, or the CPS affidavit, I'm sorry.
Without objection, notice so taken.
Thank you, Your Honor. Ms. Lamont, can you please state your full name for the record?
Maria Angelica Lamont.
And how are you employed?
I'm a certified guardianship specialist 3 for Health and Human Services Commission.
And from your employment, are you familiar with the case of Ms. Jennifer Maldonado?
Yes.
And how did the Health and Human Services Commission become involved with Ms. Maldonado?
We received a referral from CPS on August 5th, 2025.
And how old is Ms. Maldonado?
She's currently 19 years old
And what county does Ms. Maldonado reside in?
in Webb County.
And does Ms. Maldonado own any property?
No, she doesn't.
Okay, and are you aware of how much her monthly income is?
Yes, it's $967.
Okay,
And Social
and
Security benefits. I'm sorry.
okay, thank you. And in your opinion, is she indigent?
Yes.
And can you tell the court the exact nature of Ms. Maldonado's incapacity?
She's autistic with mild intellectual disabilities.
And based on your personal observations, in your opinion, is Ms. Maldonado able to properly take care of herself?
No.
And why not?
She requires supervision, assistance with her finances, and assistance with providing food and shelter for herself.
Okay, and does Ms. Maldonado have any family members?
She does.
And who are those family members?
She does have a mother and a father and 2 siblings.
Okay, and does she have contact with any family members?
No, she doesn't, and she doesn't wish to have any contact with them.
And have the parental rights of Ms. Maldonado's biological parents been terminated?
No.
Are you aware of the location of the parents?
No, their whereabouts are unknown.
Okay, and do you know when the last time Ms. Maldonado had contact with her parents was?
November 27, 2023.
Okay, and do you know if at that point the mother was interested or involved with Ms. Maldonado?
No, she was not interested. We haven't
And-
heard from her since
Since when?
2023.
Okay, and have you executed and filed an affidavit stating that notice of this guardianship has been given to all known family members?
Yes,
And HHSC did do a citation by publication for the mother, is that correct?
correct.
Okay, and in your experience, has there been any other family involvement with Ms. Maldonado?
No, none whatsoever.
So is it safe to say that no family members have contacted you interested in assuming guardianship of Ms. Maldonado?
Correct.
And did HHSC explore other least restrictive alternatives to guardianship?
Well, she was a referral from CPS. There aren't any family members willing to take the guardianship. There aren't any family friends that have come forward. So there wasn't anyone else that was willing to take a guardianship.
But as far as supports and services and things in that nature, was Ms. Maldonado able to understand and appreciate the services or the nature of those supports and services?
No,
Okay, so are you asking that this court be appointed or appoint the Health and Human Services Commission as guardian of the person?
yes,
And do you feel it's in Ms. Maldonado's best interest for HHSC to be appointed?
yes,
Is HHSC qualified to act as guardian?
yes, we are.
Is HHSC required to post a bond?
No,
And are you prepared to take an oath on behalf of the Health and Human Services Commission?
yes, I am.
Your Honor, at this time, I'll pass the witness.
Any questions for this witness, Mr. Warstack?
Judge, can you hear me?
Yes.
Okay, I'm sorry.
Any questions for this witness?
Yes, Judge. Real quickly, Ms. Lamont, you and I have spoken on at least 2 occasions, correct?
Correct,
And the last time we spoke, I think was February 11th, 2026.
correct,
And during that conversation you had with me, we were discussing the basis for this guardianship, and we reviewed your affidavit that's attached to the application.
correct.
Has anything changed since we spoke related to either the proposed ward or your affidavit attached to the application?
No,
Pass the witness, Judge.
Any further questions for this witness, Ms. Bonilla?
No, Your Honor, no further questions.
Any other witnesses?
No other witnesses, Your Honor.
You may close.
Your Honor, at this point, I would just ask that this court appoint the Health and Human Services Commission as a guardian of Ms. Maldonado. She needs assistance with the tasks of daily living, including providing food, shelter, clothing for herself. She's very happy. She's very happy-go-lucky. She was great. She spoke with us for hours and, she seems very content on where she's at. The plan is to keep her in her current residence. She just graduated high school. She does have plans for herself. So we would like to see her continue on a good path and hopefully get her to where she can maybe one day be restored.
Understood. Your report and recommendation, Mr. Warstack?
Yes, Your Honor. So I filed my report in this case on February 12th, 2026, and I just asked the court to take judicial notice of it. It speaks for itself. But I would like to summarize some of my conclusions based on what I've done in the case. I spoke with, obviously, Ms. Lamont. I've spoken with Ms. Bonilla as well. I also spoke with Noel Jaramillo, who is a caregiver at one of the facilities in Laredo. And I've spoken with the proposed ward, and I agree with Ms. Bonilla that she functions at a higher level than I expected. However, based on everything that I've done in this case, I believe that Jennifer Maldonado is incapacitated as defined by the Texas Estates Code. At this time, I think that the appointment of a guardian is necessary and in the proposed ward's best interest. I am not aware of any less restrictive means that would adequately protect the proposed ward at this point. And I have no objection to and recommend the appointment of the Texas Health and Human Services Commission as guardian of the person of the proposed ward as requested in the application, Judge.
All right. Final word, Ms. Bonilla?
Nothing further, Your Honor.
One other thing, Judge, if I may,
Yes, sir.
because the department doesn't pay ad litem fees, this one has to run through the county. So I did file a motion for attorney ad litem fees with the court. It has the Webb County request for payment of attorney's fees voucher, an attorney's fees affidavit signed by me, my timesheet, and a W-9 attached to it. And so my total fees, Your Honor, for all the time that I put in the case, it adds up to $4,590. But what I'm asking the court to do is to award me a reduced flat fee in the amount of $2,500.
And you said there's an affidavit to that effect.
There's an affidavit, and also my timesheet with all my tasks and the time that I spent on it is attached as Exhibit A to the motion for attorney ad litem fees.
All right. Anything else from any person? In the matter of Jennifer Jenny Maldonado, cause number 2025 JB, excuse me. 2025 PB 666L2. The court at this time finds that it has jurisdiction over this matter. The court hereby takes judicial notice once more of the entire case file. The court finds, based on the court file, the pleadings, the testimony, and the assertions here today on the record and the testimony, the court finds that Jennifer Maldonado is incapacitated. The court finds that she is in need of a guardian. The court finds that there are no lesser restrictive means that could accomplish the purposes of her well-being and her protection. The court finds that it is in this person's best interest to appoint Health and Human Services to be guardian over her person. The court finds that all of the necessary prerequisites and requirements in the Estates Code necessary to grant the request have been met. The court hereby grants the request, appoints the Health and Human Services Commission as the guardian over Jennifer Maldonado. The court takes judicial notice and the court has signed off on that order. The court finds that Mr. Bruce Warstack has provided legal services in this case. The court finds that given the time complexity and his years of practice, the court finds that $2,500 are reasonable and necessary attorney's fees. They are so ordered. Mr. Warstack, do you have an order granting that request?
You're on mute, Mr. Warstack.
I'm sorry about that. I do not think I filed an order with the motion, Judge, but there's a voucher. I think that the court has to either process or sign off on to make the process, happen so I can get paid. That's how I did it the last time. But if you would like me to submit an order, I'll be happy to do so.
Yes, court administrator, what is the best administrative process for those fees to be paid now that they've been ordered on the record?
It needs to be an order and I attach it as an exhibit to the voucher.
Okay.
All right, so Mr. Warstack, these are the orders due to the court honor before
31st at 12 noon by submission.
August 31st at noon by submission. All right, anything else on this case, Ms. Noriega? Anything else on this case, Ms. Bonilla?
Nothing further, Your Honor.
All right, I wish everyone here well, but more importantly, I wish Jennifer all the best.
Thank you, Your
Have a
Honor.
good
May we
day,
be
everyone.
excused?
Yes, have a good day.
Thank you,
Thank
Judge.
you.
Bye-bye.
Next
Thank
in
you.
person is Counsel Josh Favila, page 2, number 3.
It is Artista versus Cristina Mendoza, cause number 2025 CVD 45L2. Mr. Davila, who do you represent?
Good afternoon, Judge. I am here representing Cristina Mendoza. I'm actually here on behalf of Mr. Tejas.
Mr.
Sorry, can you hear me?
Mr. Davila is here on behalf of Mr. Tejas. Mr. Davila is present in person. Is Mr. Adrian Chapa, it is Artista Cristina Mendoza present?
Ms. Mendoza is present online, Your Honor.
Waiting for her to speak up. Are you Cristina
I'm here.
Mendoza?
Yes.
Welcome to court, Ms. Mendoza. The court marks you present. You're participating by video conference, ostensibly from the office of your lawyer. Once more, Adrian Chapa, it is Artista. Any other persons present? Court finds no other persons are present. Mr. Davila, what is the announcement?
Judge, we're here on two motions, a motion to disqualify the attorney and defense's motion on summary judgment. I don't know if the courts had an opportunity, because I know there were subsequent filings to our motions and responses from the plaintiff. So I don't know if the courts had a chance to review all of those. Seeing how Mr. Chapa's not here, I don't know how the court would like to proceed, or I would just go forward with my argument, Your Honor.
This is your motion?
The original motion for summary judgment is ours, yes, and the motion to disqualify the attorney was also filed by us, by Mr. Tejas.
Well, there's a motion for continuance based on federal court, and Mr. Chapa notes that he'll be out from September the 2nd to September the 14th. What is the response to the motion for continuance?
Your Honor, we're in opposition to it. I mean, that's at least us on the record. There's not much we can do if he's not here, but our position is, Your Honor, that this has been going back and forth, and considering the motions, we're opposed to a continuance.
Well, can do one of two things. I can reschedule this, and the rescheduling is going to be an issue because I can reschedule it to a busy docket date, which means folks aren't going to be given sufficient time, I think, on all cases for, I mean, if every case is contested, then we will definitively run out of time. Or I can just set this by submission. I mean, this is your motion. Are you or Mr. Diaz requesting argument?
No, Your Honor, I believe that all of our facts and allegations are in the motion for summary judgment, as well as in the motion to have Mr. Chapa, I guess, disqualified as the attorney.
But that's a separate, so I'm just talking about the summary judgment. I can do the summary the court can hear the summary judgment by submission because there's no evidence or testimony received. Then the motion to disqualify and the motion to compel, that would require evidence and or testimony.
I agree, Judge. I think that you could make a decision based on just the motion for summary judgment, based on the submission on both parties, since there have been, I want to say, 2 from us and 2 responses from Mr. Chapa. As for the other one, we can do a short reset, and if Your Honor would like, we can argue that motion separate.
There just aren't hearings between now and then in the time frame that Mr. Chapa needs. I tell you what, this court has until September the 15th to hear that motion for summary judgment. So let me just set this then, September the 15th at 2 p.m. So the court is going to hear that motion for summary judgment, the motion to disqualify, and the motion to compel, all on September the 15th at 2. But I need every person to prepare proposed orders because that's the date. No, and then I have 90 days to rule. Never mind. All right, so I'll come back on September the 15th. The court finds that there is good cause, reason, and basis to extend the MSJ hearing until then. All right, anything else on this case, Mr. Davila?
That's all I have, Judge.
Any other cases for Mr. Davila or Mr. Diaz?
No, Your Honor.
It's good to see you, counsel.
You
Have a
too,
good
Judge. Have a good
Tuesday.
Next online is Council Cristina Flores, page 5, number 12.
In the estate of Maria Magdalena Guajardo, cause number 2026 PB 751L2. Good afternoon, Ms. Flores.
Good afternoon, Your Honor.
Court martial present, you're participating by video conference.
Mr. Icorst is
Ronald.
present.
Ronald Icorst, are you present? Icorst, please step forward. Speak into the microphone and tell the court, are you Ronald Dean Icorst?
I am.
Welcome to court, Mr. Icorst, the court martial present in person. As you can see and hear from that device, your lawyer is present and participating by video conference. Counsel, what is the announcement?
We're ready to go forward, Your Honor. It's an application to probate will with, and for letters, testamentary.
All right, Mr. Icorst, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
You may lower your hand. Ms. Flores, go ahead.
Thank you, Your Honor. Can I just get you to state your name for the record?
Ronald Dean Icorst.
And the decedent, Ms. Maria Magdalena Guajardo, is your maternal aunt, deceased on May 7th of 2026 in Webb County at the age of 82 years old. Is that correct?
That is correct.
And she was domiciled at the time of her death at 802 Eaton Lane here in Laredo County, Webb County, Texas.
That is correct.
Her principal estate was in this county as well at the time of her death, and she was residing here at the time of her death and prior to her death, correct?
That is correct.
She owned property generally described as real estate, cash, personal effects, household goods, in excess of $3 million. Is that correct?
That is correct.
And she left a will, which we tendered to the court, and the original will that was dated February 9th, 2018, and that will was never revoked.
Correct.
And there is a necessity for the administration of this estate, specifically in that the decedent, Ms. Guajardo, had sold some properties and she owner financed those properties. And so those monthly payments are being received through her bank account via direct deposit with Falcon Bank.
That
Correct?
is correct.
And at the time of the time that she prepared that will, there was no children born or adopted by her.
That is correct.
And there was no marriage that was ever dissolved after she made this will.
Correct.
And you, Ronald D. Nyquist, the will names that you serve as the independent executor and that you are to act independently without a bond. Is that correct?
Correct.
And you also reside in Webb County, in Texas.
Correct.
And you've not been convicted of a felony ever.
I have not.
And there's no reason that exists why you would be disqualified from serving as the executor and from accepting the letters testamentary by this court.
Correct.
There is no state or governmental agency of the state or charitable organization that is named in the will as a DIC, correct?
Correct.
And you read that original will. It was self-proved in the manner prescribed by law. And the witnesses on that will are Antonia P. Vasquez and Renee Diaz.
Correct.
And are you asking the court that the will be admitted to probate and that the court issue the letters testamentary?
I am.
Thank you. I have no further questions, Your Honor. I think that's it.
Mr. Nyquist, did the court hear you correctly? This is your aunt's.
It's my aunt, yes.
Right, Mr. Nyquist, in the case of your aunt, cause number 2026 PB 751L2, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your request. The court hereby takes judicial notice of the entire case file, which includes your aunt's original death certificate, her original will, the citation by posting, and I have now had the benefit of hearing your testimony. The court finds that your aunt unfortunately died or passed away on the 7th day of May 2026 at the age of 82, having left a valid, executed, and unrevoked will dated February the 9th, 2018. The court finds that there's a necessity to administer your aunt's estate. The court finds that you are named in the will, you are qualified, and you're not disqualified from serving. The court finds that neither the state of Texas nor any charitable organization have been named as DICs. The court finds that you have complied with all of the requirements necessary for the court to grant your request. For all these reasons, the court's grant your request, admits your mother's will, your aunt's will into probate, and will cause letters of testamentary to be issued out to you. The court has signed an order provided and filed by your lawyer. I am tendering that signed order to the clerk's office. The inventory on your aunt's case is due to the court on or before November the 10th at 2 p.m. Keep in contact with your lawyer. You need to sign an oath and a proof of death.
Yeah,
Yes.
we do have that here for him to sign in.
Oh, please sign that now.
Thank you.
Yes.
We got scared, Your Honor. We thought we were going to get caught behind that big hearing. I thought I was going to have to drive back to the courthouse.
This case is complete now. Mr. Nyquist, do you have any questions for the court?
Not at this time.
Anything else to put on the record, Ms. Flores?
No, Your Honor, that's all. May we be excused.
Good to see you, Ms. Flores, and Mr. Nyquist. I wish you well, and you have the court's condolences.
Thank you.
Have a good day.
Thank you.
Thank you, Your Honor.
Yes.
Next is Counsel Olivero Canales, page 2, number 4.
This is in the matter of Ricardo Javier Rios, cause number 2025 PB 648L2. Good afternoon, Mr. Canales.
Good afternoon, Judge.
Court marks you present. You're participating by video conference. Ricardo Rios Jr., Vanessa Lee Ramos. Any other persons present?
No, Your Honor, they're not present. We're not ready to go forward today. There has been some progress. We amended our application to include the mother We have provided for the certificate examination. The parties are in the course of finishing up their guardianship courses. And I think the court dismissal date, I think of September 15th. Hopefully we can have everything done by then, Your Honor.
All right, the court will call that case then. Any other cases for Mr. Canales?
No, Your Honor.
It's good to see you, counsel. Have a good rest of the day.
Thank you, Your Honor.
All cases called for in person and online, Your Honor.
Just one case, page 6, case 14, JCN4NS Trucking LLC versus Mission Crane Service LLC, cause number 2026 CVH 302C3. Marcel Knotson, Mission Crane Service LLC. Any persons present on this case?
Mr. Nelson was present earlier, Your Honor. I just don't know why he didn't stay online.
Let me ask the clerk's office, has anything been filed into the case for this case?
Your Honor.
I tell you what, the court reviewed this case. The court signed an order, and citation was not requested by the plaintiff for a month and a half. So I tell you what, let's give the court 2 dates, Ms. Noriega. Give us one last calendar call
That'll be October 6th at 2 p.m.
and give us a dismissal date.
Dismissal date in November, Your Honor, will be November 12th at 2 p.m.
So ordered. The court confirms that that concludes all of the cases, save and except for the contested matter. Brogo Transport LLC versus Interfleet Brokerage, cause number 2025 CVD 44L2. Court marks Counsel Barrera present in person, Mr. Morris, Counsel Morris present by video conference, and then Mr. Gonzalez and Mr. Mata on behalf of their respective businesses, I guess. All right, Mr. Barrera, who is your first witness?
Housekeeping matters with respect to
Inaudible.
planning on,
Start again into the microphone.
I believe there's some housekeeping matters with respect to some exhibits, and there's gonna be some objection, with respect to some text messages. That I don't know if the court wants to rule on before we start.
I have no idea what you're talking about. What is the subject of the request?
Well, I'm planning on, requesting to admit some evidence, which are text messages, which I believe Mr. Morris is gonna object to. I'm not sure if we wanna, hear that first
It's a
or.
hypothetical until it happens. So pursuant to the local rules, this court's local rules, just ask the court staff to prompt the case line exhibit number that you would like prompted, ask questions. If it's authenticated, ask that it be admitted. If there's an objection, I'll rule on it, and then we'll go from there.
Okay, because my exhibits are in physical paper,
They're all excluded
unless they're all excluded.
unless they're uploaded 24 hours before into case center.
We did do that as well, Judge. We did
Okay.
it last time.
Okay,
just-
so just refer, so remember, as you're asking your client or witness to testify to document, ask that the court staff prompt, scroll up or down, and then try to authenticate, and then ask they be admitted, and then Mr. Morris will object or not object as.
Okay, I just don't have, the website where you upload them. I don't have that on my laptop, so I can't see the list. But I mean, I can get it.
Hmm. You gave the court an hour and a half designation. Was that total or is that per side?
No, I believe that's total. I believe if we're not gonna do an opening argument and it was gonna be a very short one, if we're gonna dispense with that, which I'm fine with. Take my client's testimony, probably take 30 minutes.
Mr. Morris, any objection to equalizing the argument, 30 minutes per side?
No, Your Honor.
All right. And I tell you what, the court will start a 30-minute timer per side, and that's 30 minutes total. So for example, it's kind of like a chess timer. So any questions that Mr. Barrera asks, that eats up into his time. If there's an objection, then that time pauses, and then Mr. Morris's time starts until that objection is resolved, and then we take it from there. So I tell you what, in the interest of justice and judicial economy, the court will stand at ease for a few minutes, and then we will commence. Ms. Noriega?
I was just going to request co-host capabilities, Your Honor, because I froze for a bit and had to,
All right.
just so that I'm able to share. Thank you.
Is that, are those the exhibits that we uploaded the last time?
I don't. Ms. Noriega, are you probate civil docket? Is that your device?
Probate, yeah, no, Your Honor.
What is the name of your device?
Probate, civil.
Right. All right. Court will stand at ease for a few minutes, and then we will commence this hearing. Stand by, please.
Thank you.
Brogo Transport, ¿podría por favor ponerse su teléfono a su oído? Necesito saber que me escucha.
Yeah.
No, no. No.
Testing mic by Council Frank Barrera. Can you all hear him?
It's not on.
Listen. Should turn green. Okay.
Hello, can you hear me?
Audible.
Okay. Is that how close you're going to be as your,
When I speak,
yes, just so that I can.
should I get that close? I can.
You can put the mic closer to you, Council.
Okay,
Yeah.
great. Thank
Okay.
you.
Thank you.
Court is back in session and we are on the record. Brogo versus Interflex, cause number 2025 CBD 44L2. Time is now 5:03. Court has heard time estimates for each side. Parties are estimating about an hour. Court is going to start timers for each side as soon as they commence for half an hour each. Mr. Barrera, who is your first witness?
Your Honor, the first witness is Armando Gonzalez.
Mr. Gonzalez, step in front of this microphone. Raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Lo juro.
I swear.
You may lower your hand. Your time, Mr. Barrera, begins after your first question. Go ahead.
Thank you, Your Honor. Can you please state your name for the record?
Armando González.
Armando González.
Where do you live and what do you do for a living?
Vivo en Laredo, Texas y soy propietario de Brogo Transport, una empresa de transporte.
I live in Laredo, Texas, and I am an owner of Brogo Transport, a transportation company.
How long have you owned and operated Brogo Transport LLC?
Desde el 2020.
Since 2020.
What kind of company is Brogo Transport?
Es una empresa de transporte que entrega mercancía por todo el país.
It is a business that transports merchandise all over the country.
When did you first come in contact with the defendant counterplaintiff Interflex Brokerage?
Hace aproximadamente 3 años comenzamos a trabajar con ellos entregando carga.
Approximately 3 years ago, we started working with them and we were delivering goods.
Can you please briefly describe your business relationship that you had with Interflex Brokerage?
Interflex Brokerage es un intermediario de transporte que te paga para mover mercancía de punto A a punto B.
Interflex is a middle company that pays you. It's also a transportation company that pays you in order to transport merchandise from point A to point B.
Did your company Brogo Transport accept 6 loads from Interflex Brokerage in September of 2024?
Correcto.
Correct.
And were these 6 loads transported and delivered to their destinations by your company, your drivers, and your trucks?
Correcto. Correcto.
Correct.
Were each of these 6 loads delivered in a timely manner?
Correcto.
Correct.
Did Interflat Brokerage ever pay you for the transportation services you provided with respect to these 6 loads?
No.
No.
Is Interflat Brokerage's failure to pay these 6 loads from September 2024 the basis of this lawsuit?
Sí, es lo que es.
Yes, that's what it is.
Your Honor, at this time, I'd like to show what I'm going to be requesting to be admitted as Exhibit A. It's number 15 on the case line website.
Court staff will prompt case center 15.
Mr. Gonzalez, do you see the document on the screen?
Correcto.
Can you tell the court what
Correct.
can you tell the court what this is? If you can scroll down, up and down, please, just so you can.
Estos son los documentos de carga de las 6 cargas que mi empresa entregó para Interfront Brokers en septiembre del 2024, por las que nunca me pagaron. Para cada carga hay una confirmación de transportista, una factura y un conocimiento de embarque.
These are the documents in regards to the 6 loads that were done in September of 2024 that were never paid by Interflit. These have a confirmation, they have an invoice.
Is this a true and correct copy of the carrier confirmation and load paperwork for the loads that are at issue in this lawsuit?
Correcto. Correcto.
Correct.
Were these records made and kept in the regular course of business?
Correcto.
Your Honor,
Correct.
Your Honor, I'd like to enter this document as Counter Defendant's Exhibit A.
Any objection to the admission of case center number 15 as plaintiff's 1?
No, Your Honor.
Plaintiff's 1, which is case center 15, is they're admitted into evidence without objection.
Can you please tell me the different destinations your drivers had to travel to in order to deliver each of the 6 loads that are at issue?
Sí, la primera carga fue la 1508, fue llevada a Braston, Kentucky, por una tarifa acordada de $2,850. La segunda carga es invoice 1503, fue llevada a Garland, Texas, por una tarifa de $1,200. La tercera carga 1516 fue llevada a Jacksonville, Florida, por una tarifa acordada de $3,150.
Translation, please.
The first load was taken in regards to invoice 1508 to Kentucky with an agreed amount of $2,850. The second load was invoice 1503 to Garland, Texas with an agreed amount of $1,200. The third load of invoice 1516 to Jackson, Florida with an agreed amount of $3,550.
González, you may continue.
Señor González, ¿puede continuar un poco más despacio, por favor?
Ok. La carga 1519 fue llevada a Jacksonville, Florida, por una tarifa acordada de $3,000. La quinta carga 1523 fue llevada a Garland, Texas, por una tarifa de $1,200. Y la sexta carga fue llevada para Newark, New Jersey, por una tarifa acordada de $4,500.
The fourth load invoice 1519 was taken to Jackson, Florida for an agreed amount of $3,000. The fifth load of invoice 1523 was to Garland, Texas for an agreed amount of $1,200, and the sixth load was taken to Newark, New Jersey with an agreed amount of $4,500.
In total, how much did Interflat Brokerage agree to pay your company for delivering these 6 loads?
$15,900.
$15,900.
Did you yourself deliver these loads to these destinations, Mr. Gonzalez?
No, los conductores que contrató mi empresa para entregar las cargas.
No, the drivers that my company hired to take these loads and deliver them.
Did you pay your drivers their fees for performing this work?
Correcto.
Correct.
In total, how much did you pay your drivers to deliver these 6 loads?
Les pagué $6,255.
I paid $6,255.
Did you incur any other expenses in transporting these 6 loads for interflight brokerage?
Sí, mi empresa pagó $5,995 en combustible. Mis camiones sufrieron desgaste al haber recorrido 13,900 millas para entregar las 6 cargas.
Yes. My company had an expense of $5,995 in gas. My trucks suffered wear and tear due to the 13,900 miles that were driven in order to deliver this 6 loads.
So not only were you not paid for performing these services, you've actually spent money to deliver these loads. Is that true?
Sí.
Yes.
In total, how much did you spend out of pocket delivering these 6 loads for brokerage interflight brokerage?
Entre pagar a mis conductores y el costo de combustible, mi empresa gastó $12,220 para la entrega de las cargas. También he tenido que pagar el honorario del representante en este asunto.
In between paying my drivers and gas, it was an out-of-pocket expense of $12,220, and I've had to pay my attorney to represent me in this case.
Your Honor, at this time, I'd like to show what number 16 on case line entitled Exhibit B, Master Invoice.
Court staff will prompt case center. Did you say 16?
It's number 16.
All right, court staff will prompt.
Mr. Gonzalez, can you see the document that's been pulled up?
Correcto.
Can you tell me-
Correct.
Can you tell me what this document is?
Son las 6 facturas que nos deben.
Those are the 6 invoices that are owed.
It is a true and correct copy of Broker Transport's master invoice for the loads that are at issue in this case.
Correcto. Correcto.
Correct.
Was this record made and kept in the regular course of business?
Sí.
Yes.
Your Honor, at this time, I'd like to request to admit this document as Exhibit B.
Any objection to the court admitting case center 16 as plaintiffs 2?
No, Your Honor.
Plaintiffs 2 is admitted without objection.
Mr. Gonzalez, what is the total amount you invoiced Interfed Brokerage for the 6 loads you delivered in September 2024 that are the basis of this lawsuit?
$15,900.
$15,900.
Was that the amount agreed to by both parties?
Correcto.
Correct.
And where can that agreement be seen?
En las confirmaciones que le mostré anteriormente.
In the confirmation notices that were shown prior.
Now, when you would accept loads from Interfed Brokerage in the past prior to September 2024, how would they pay you?
Me pagaban a través de una compañía externa llamada Freight Factoring Specialist. Yo facturaría a FFS, me pagarían en menos de 24 horas y me cobrarían una pequeña tasa de servicio. FFS entonces cobraría la cantidad de Interfed Brokerage.
They would pay me through a third company, FleetPack FFS. They would pay me in 24 hours and they would charge me some sort of interest or fee, but then they would charge Interflit.
And is that how you were going to be paid for the 6 loads from September 2024? That's the basis of this lawsuit?
No,
No,
And why not?
porque recibí una correspondencia de mi factoría de mercancías que me informaba que ya no aceptarían cargas de Interfleet por el historial de pagos que estaban retrasados.
because I was advised that they were no longer going to be paying anything that had to do with Interflit due to their non-payment.
Your Honor, at this time, I'd like to pull up number 18, entitled Exhibit D, Freight Factoring Specialist Emails.
Court staff will prompt case center 18.
Mr. Gonzalez, can you see the emails that have been pulled up?
Sí,
Yes,
Can you tell the court what this document is? These documents are.
son copias de correos electrónicos que recibí de mi factoría donde me están diciendo que está restringido.
these are emails. There are copies of the emails that I received where they're telling me that they are restricted.
Is it the true and correct copy of the emails you received from Freight Factoring Services?
Sí, correcto.
Yes, correct.
And was this email or this record made and kept in the regular course of business?
Correcto.
Correct.
Your Honor, at this time, I'd like to request to admit this document as Exhibit D.
Any objection to case center 18 being admitted as plaintiffs 3?
No, Your Honor.
It's admitted without objection.
Reading the email, it's dated April 29th, 2024 from Freight Factoring Services. I'm going to read it and ask you some questions. I don't know if the court wants to put it back up, Judge, on the screen. The email reads, "Dear client, please be advised that the following broker is now on restricted status as they have a very past due load. Interfleet brokerage, please do not haul any additional loads for the broker as we will not be able to purchase them. Thank you for your attention to this matter." Did I read that correctly, Mr. Fernandez?
Correcto.
Correct.
And there's a second email, if we scroll down on this exhibit dated June 27th, 2024.
Hay un segundo correo, el cual está interpuesto como junio 27 del 2024. My apologies, the call was lost where I was interpreting simultaneous. Let me try again. 1 second.
Madam Mayor, how much time we have?
13 minutes.
¿Me llamará de nuevo? Sí, bueno. Ok, ya está de nuevo.
Mr. Barrera, go ahead.
Thank you. This second email dated June 27th, 2024, also from Freight Factoring Services, reads exactly the same as the first. I'll go ahead and read it for the record. It reads, "Dear client, Please be advised that the following broker is now on a restricted status as they have a very past due load, Interflat Brokerage LLC. Please do not haul any additional loads for the broker as we are not able to purchase them. Thank you for your attention to this matter. My question, Mr. Gonzalez, is approximately 4 months before, and then again 2 months before Interflat Brokerage asked you to transport the loads that are at issue in this lawsuit, you received an email from Freight Factoring Services advising you that they would no longer buy the accounts from Interflat Brokerage because Interflat Brokerage was taking too long to pay. Is that correct?
Correcto.
Correct.
Why did you accept the loads if Freight Factoring Services warned you about taking them?
Tenía una relación comercial con ellos, me pidieron ayuda y yo decidí ayudarles. Les creí que cuando me dijeron que me pagarían.
I had a working relationship with them and they asked for my help and I decided to help them believing that they would pay me.
If you were not going to be paid via Freight Factoring Services, what was the agreement you had with Interflat Brokerage about how you were to be paid?
Acepté las cargas solo con la condición de que me pagarían a través de Quick Pay, es decir, que me pagarían de 24 a 48 horas el mismo tiempo que tardaría FFS en pagarme. Acepté las cargas solo con la condición de que me pagarían a través de Quick Pay, es decir, que me pagarían entre 24 y 48 horas el mismo tiempo que tardaría FFS en pagarme.
I accepted the loads because they said that they were going to pay me through Quick Pay, which would take 24 through 48 hours, exactly the same process that we had with FFS.
And did Interflat Brokerage agree to pay you in that time frame?
Sí, correcto.
And
Yes,
what,
correct.
and what happened when you invoiced Interflat Brokerage for each of the 6 loads that we're here for today?
Después de que mis conductores entregaron la carga, mi empresa envió una factura por cada carga con la misma cantidad que aparece en la confirmación del transportista a Interflat Brokerage, pero me dieron largas durante meses y nunca recibí el pago, lo que me obligó a presentar una demanda contra ellos en el Tribunal de Reclamaciones Menores.
I sent them the invoices, the ones that were reflected with the same amounts, the ones that had the confirmation, and they just wouldn't answer. And it was months and months of it. And that's why I was obligated to file suit in the JP courts.
Did Interflat Brokerage ever complain in any way about Broker Transport's performance in delivering these 6 loads?
Negativo.
Negative.
Did Interflat Brokerage ever deny that they owed you $15,900 for delivering these loads?
Negativo.
Negative.
Did Interflat Brokerage ever give you any reason as to why they were refusing to pay you during the first 2 months after you invoiced them, after you performed services delivering these loads?
Negativo.
Negative.
How would you and how would Brogo Transport and Interflat Brokerage communicate to assign loads?
Por teléfono y un grupo que tenemos de WhatsApp, donde hay empleados de mi empresa y empleados de Interflat.
Through telephone and through a WhatsApp group where there are employees of my business and employees of Interflat.
Your Honor, at this time, I'd like to pull up what is number 17 on the page line and entitled Exhibit C text messages.
Court staff will prompt.
Mr. Gonzalez, can you see the text messages that have been pulled up?
Correcto.
Can you tell the court?
Correct.
Can you tell the court what this is?
Son mensajes de mi empresa y de la empresa de Interfleet.
Those are messages between my business and the business Interfleet.
Your Honor, if I may object, I think we're gonna come up here on some objectionable content.
What is the objection?
The objection is these are Spanish language documents and no translation was offered pursuant to Rule of Evidence 1009. And we haven't received a certified translation, not even a translation at all.
Your Honor, if I may, that can be cured by reading them into the record and having the court interpreter interpret them. This is an industry that two companies largely conducted in Spanish. The text messages are in Spanish.
And I would just respond to that. The rule doesn't have any kind of exceptions built into it. It's very straightforward. For documents like these to be used, they need to be admitted with that accompanying translation.
These are party admissions. They're text messages directly from the parties.
The objection is sustained. I'm very familiar with both in practice and on the bench with Texas Rules of Evidence 1009 requires the translation of documents so that there's sufficient time to object. That is different from an interpretation where there is no opportunity to cure. I suspect that being one of the built-in provisions into that Rules of Evidence. So to the extent that there's any Spanish language documents that don't comply with Rule 1009 of the Rules of Evidence, the objection is sustained. Mr. Barrera.
Your Honor, may I ask how much time I have?
5 minutes, 5.5.
At any point did anybody from Interfleet Brokerage ever deny that they owed you the $15,900 for the services you performed?
Negativo.
Negative.
Now, in transporting the cargo for these 6 loads, did your company use trailers from Interfleet Brokerage?
Correcto.
Correct.
How many trailers from Interfleet Brokerage did you use, and are any of those trailers still in your possession?
Usamos 3 remolques y solo 2 están en mi posición.
We used 3 trailers and there's only 2 under my possession.
Did you ever tell Interfleet Brokerage that they could not pick up the 2 trailers that are in your possession?
No, al contrario, les envió un correo pidiéndoles que recogieran sus remolques y que metieran el pago, cosa que nunca hicieron.
On the contrary, I sent an email and I told them to pick up the trailers and for payment to be turned over. They did none.
Your Honor, at this time, I'd like to pull up what's number 19 on case line, entitled Exhibit E, September 11, 2024 email.
Court sample prompt case number 19. Did you say 19 or 18?
19.
19.
Your Honor, would it be possible to request more time? I didn't anticipate I didn't take into account the translation.
It's exactly why we're doing it simultaneously. Had we not done it simultaneously, I assure you we'd be here for triple the time. Mr. Morris, the request is, let me stop this. Mr. Morris, the request is for additional time. Any objection?
No objection, Your Honor.
So I tell you what, so the request is for more than 30 minutes for one side. What's good for one is good for all. So Mr. Morris would likely get more than 30 minutes. We're not going to be here till 7 or 8. So I tell you what, let me start giving you some dates to see if you disagree. Sorry, not that you disagree, if you object to a date certain.
Judge, I may have a question, but it's not gonna be much more. I just want to let you know, if we can finish today. But
Right,
whatever the court-
but you're gonna look at 45 minutes or so, and then Mr. Morris is gonna do the same thing. That puts us here till at least 6:30. So, I guess let me give you the first date. Mr. Barrera, any objection to August the 18th at 10 a.m.?
1 second. Judge. No objection, Judge.
Mr. Morris, any objection to August the 18th at 10 a.m.?
If we can do hybrid, Your Honor, no objection.
Any objection to hybrid, Mr. Barrera?
No objection, Judge.
All right, this case will continue to be heard on August 18th at 10 a.m. The court notes Mr. Barrera has 5 minutes left. Mr. Morris has 5 minutes left, understanding that about 15 minutes will be added to each side. That doesn't, the court hasn't even contemplated closing arguments, which the court must, or would at least like to. I'm sure I have to, but I would like to hear summaries of what each of you believe the evidence showed and what your client is requesting. Before we break until August the 18th at 10, anything else for the record, Mr. Barrera?
No, Your Honor.
Mr. Morris, anything else for the record?
No, Your Honor.
All right, we stand at ease on this case until August 18th at 10 a.m. I wish everyone a good day.
Thank you, Your Honor.
Your Honor.
Ms. Noriega, have all cases been called on this docket?
Yes, they have.
All right, that now concludes this docket held in person and by video conference for Tuesday, August the 4th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, like the clerk's office and the sheriff's office that still join us. Thank you all. The court wishes everyone a good night.